have like three short introductions here by the speakers, so about 12 minutes or so, and then we have plenty time, not plenty maybe, but a lot of time for discussion. So I would think it's a good idea maybe if Simonetta, if you start and then we can go to Inge and then.
Okay, so thank you so much. I hope you can hear me, but yeah, I think so. Thank you so much for the very, the lovely invitation. We met already in Südtirol a few years ago, and it has been a very nice occasion with many economists there in the room as well. So I would like to make only 4 brief remarks here. Well, you said today it's going to be the 4th trialogue, perhaps the decisive one, a very important date. Well, actually, the 24th of March 2004 was a very important date already. So exactly 18 years ago, it was the day in which the EU Microsoft decision was taken. So, I mean, somehow for us antitrust geeks, it's already quite an important day. Well, so my 4 points. The first one is that just briefly about the nature of the Digital Markets Act. So the comparative perspective has already been taken care of by Professor Jens, so it's going to be a little bit quicker and perhaps be looking at some more developments in South Korea and things like that. And then I will definitely try to spend a couple of minutes on interoperability. Professor Jens already mentioned it in the sense of vertical interoperability, ancillary services, but I think it's very important also from the point of view of network effects that we discuss also horizontal interoperability. And then the 4th point, a little bit about future proofing, because we have here a huge piece of legislation, quite complicated. And of course, we know that digital markets change very quickly. So what about future proofing the DMA? Are we dealing here with something which is going to be outdated tomorrow, or it's already outdated today? So that's a very, very important point. So starting from the nature, well, I think it's very important, I think Inge would also discuss it, to consider that it's already part of a broader picture, the Digital Markets Act. We should not be considering it in isolation. There are many relationships with other important pieces of the legislations currently being discussed, the Digital Services Act, the Data Act, the Data Governance Act. We can also discuss cybersecurity, many other things. So it's very difficult to talk about the DMA really in isolation. So I think it's very important from the policy perspective to consider it. Then the other point we should really stress, it's a world premiere. So the Digital Markets Unit could have been first, but we are first. And so it's an ex-ante asymmetric regulation targeting specific gatekeepers, digital gatekeepers, and in predefined core platform services. So it's not just the Wild West or any possible type of platform services. There are core platform services. The list is there, pretty broad. I've just heard that there was the European Parliament suggested as one of the core platform services also connected TVs. I've just heard that it's not part of the final version of what we have now on the table, but there are many other interesting things. There are so many of the digital technologies which will inform our lives here. And then it was mentioned qualitative criteria. So I think from the the main economists here in the room, it's very important to discuss also the objectives of the DMA. We basically have 2. They were mentioned already: contestability and fairness. Okay, contestability, of course, Baumol theory, contestable markets, as it was also interpreted by the Chicago School in the sense of potential competition is great, the structure does not matter. But then, of course, Baumol perhaps has been interpreted à la cause, in the sense that it's not that is a word without transactions cost in the sense of cause, but in Baumol in the sense that, well, there are actually entry barriers and things like that. But in any case, it has been used by the Chicago School just to justify totally laissez-faire. Okay, so it's very strange to find it now, contestability in the Digital Markets Act, because you say, well, it's very strange that you use the concept of contestability to justify not only strong antitrust intervention, but regulation. So economists, of course, say, well, but what is it? Well, we don't know. Okay, possibly it's not the same concept of contestability that we know of because of Baumol and economists who have been investigated it. I don't think it makes really much sense to really look back and say, okay, what are the theories of contestability there? Digital markets are different. This is the same thing perhaps Professor Genier was saying, that it doesn't make sense perhaps to just look at the past, and we have to think forward thinking, also with regard to the concept of contestability. For instance, Vestager, our competition commissioner, mentions also the contestability together with openness, okay, which is of course pretty vague as well, but there will be a sort of interpretation of the Digital Markets Act. The second point is fairness. Again, from the economics perspective, well, Pareto optimal, efficiency is fair, things like that. But of course, we can move beyond that. We can think of order liberal thinking, the possible equity of opportunities. It's an important concept in economics there. We can think of much more modern theory, constitutional economics, even evolutionary economics has some references to fairness. There is a very nice discussion going on in the US about fairness concept, the new Brandeisians, okay? So, and there it's quite interesting because they are, of course, totally opposing the consumer welfare standard, the new Brandeisians, but it's not that they are proposing an off-the-shelf standard instead. I think there is quite a lot of experimentation going there. It's quite interesting to follow. Okay, so that's basically, so what about contestability and fairness? What do we know? Well, at the moment, perhaps not very much. We are investigating also from economic perspective, from the legal perspective. So that would be the first point about the objectives. Another important point to consider is that it's not antitrust law. Well, the Article 90A, perhaps it's an evolution of competition law. Here, it's pretty clear. They say, well, it's not traditional antitrust law. It's different, okay? We call it digital regulation. We had the regulation in telecoms for many years. It's not the same type of regulation. So there is a complementarity to competition law. So competition law, undistorted competition, whereas here, quoted from the last version of recital 10, ensure that markets where gatekeepers are present are and remain contestable and fair. And then, of course, investigation what is made. That's another part. But we already, yeah, it's quite. We need to think forward. Perhaps from the economic perspective, yes, you would have preferred to look at efficiencies. Are there efficiencies or not? Well, these are rules, okay? That's perhaps from the antitrust perspective, we will still have antitrust enforcement. Parallel to that, there will be perhaps an interesting interplay between antitrust and digital regulation, but that's going to be the future. So, what about the second aspect that I was mentioning, a little bit, the comparative perspective? Well, the comparative perspective was already covered. I don't think I have so many minutes left.
6 minutes.
Okay, so good. I think the comparative perspective is also quite interesting if we think about what has already happened. Okay, so the Digital Markets Act is going to be a world premiere. Interestingly, we have, for instance, South Korea. Okay, we have already digital regulation there concerning in-app payments. Okay, so for instance, that you go to the App Store and you want to subscribe to Spotify. Well, Spotify is not a good example now because they are out of there, but in any type of service. And then you can choose not to use in-app services offered by the App Store operator, okay? So we already have it in South Korea. So that's the world premiere, but of course, it's just one part of digital regulation and it has been applied. And interestingly, Google has already implemented the changes based on the new South Korean regulation, and they are applicable worldwide, and they are sort of already anticipating the effects of the DMA. So for instance, they are now working on a pilot, the news came yesterday, with Spotify to allow for in-app payments Okay, so it's going to change. So these rules are going to change our life. Okay? We are going to see them changing our societies, our economies. They are going to be very impactful. So you will have the possibility of choosing not to use Google's in-app service. And so it means quite a lot of new dynamics going on. What about the level of the commissions? What about the possibility of being paid for offering the display, okay, of the apps in the store, and asking for a fee for a service for it? So quite a lot of new questions emerging there. Okay, so that would be the comparative perspective put briefly. What about interoperability? Yes, we have interoperability. Well, from the economic perspective, I would say that economists, based also on Professor Eugénie's presentation, would say, well, definitely network effects. That would be the most wonderful way of dealing with that if they cause barriers that cannot be overcome. So it's very important that we consider, so from economic perspective, since we are talking here gatekeepers, okay, we are not talking here normal digital platforms, we are talking here gatekeepers. You cannot expect to have multi-homing. Okay, so they are the only ones in the market. So why not introduce interoperability broadly in the sense of, for instance, myself using Signal and wanting to communicate with my brother using WhatsApp. Okay, and then of course there is the question, I mean, it was also touched upon by Professor Eugénie, saying what about the innovation effects? Well, of course, you have to start by doing interoperability by way of some functionalities which are already there. And then the example would always be, well, emails, look at emails, there has been no progress in the last 40 years. That's totally wrong because there are protocols which are updated. So there was encryption introduced into email, spam filters is not a standard which is dead and it's not moving anywhere. So, but in the DMA, the original version of the European Commission, there was no horizontal interoperability in the sense that I'm proposing you the example of instant messaging. There were only ancillary interoperability, which is of course great. That would be the in-app service example I was making. Many other examples. There was an interesting case in Italy, for instance, concerning Google car and apps used for charging electric cars. So nice examples there. And also interoperability, so great. So what happens now? Where are we in the negotiations? Well, apparently there has been an opening by the Commission and the Council, and so perhaps we will have a sort of horizontal interoperability for instant messaging. But the devil is always in the details, so it depends on the type of interoperability. Is it by way of opening APIs? Is it by way of protocols, etc., etc.? But it's interesting because perhaps it's there. And I think from economic perspective, it's very important that it's there. Very last point that I would like to make, if I remember it. Yes, the future proofing. Well, yes, it's extremely important. Future proofing, the Commission has been thinking quite carefully about it because it's pretty clear. It's the first objection you can have. I mean, yes, the ink is not dry and it's already old. Well, yes, so there are mechanisms by way of delegated acts. I think the Commission has acquired quite a lot of flexibility, which is good news. And there is, of course, a big question mark. It depends on how it will be enforced. The national competition authorities will have a very important role in helping the Commission enforcing it. But of course, we need quite a lot of men and women power at the Commission. So quite a lot of people enforcing it. We need quite a lot of technologies. This is going to be, from my perspective, the most important aspect of the DMA. That, I mean, technologists will be working with economists, with lawyers, because very often our limit as lawyers and economists is that we don't know about the possibility from the technological point of view. So I think it's, for instance, the email example, okay? So economists recently in a report wrote, no, I mean, email has been dead on arrival. It's not dead, it's updated, and technologists tell us about it. So I think this is going to change the mentality also at the European Commission. I think it's going to be a very important effect possibly of the DMA, because I think, yes, there will be possibility of sandboxing as well, the new things that could also perhaps then percolate back to antitrust law. So it's an exciting exchange possible between digital regulation and antitrust law. So thank you.
Thank you very much, particularly for these nice illustrations. So very helpful, I guess. So then we have Inge as the next.
Thank you very much. So I would like to spend these introductory remarks to look a bit beyond the DMA as such. So as we all know, the digital market, can you hear me well? Or?
It's closer. I had to put it closer as well. Yeah.
I hope it's better. I will speak like this. I think this is much better. So I would like to look a bit beyond the DMA because indeed, as Simonetta was already saying, it is part of a bigger regulatory framework that the EU is now putting in place. And of course, we have already heard that indeed the objective of the DMA is to complement the EU competition rules as we already have by targeting obligations on these particularly powerful players, the gatekeepers. But of course, there is also obligations in the DMA that relate to other policy areas like data protection and also to the new Data Act that was published last month, which also contains rules on access to data. So I've worked myself quite a lot on this issue of access to data. So I would like to use this as a lens to look at how the DMA interacts with these other policy areas. And I will do that by looking at a trade-off that I think is becoming very important in current policies. And that is, I think, the trade-off between collective interests in competitive markets, innovative markets, and the interest of the individual. So the interest of the individual to choose what to do with his or her data. But as we know, data is social, data has externalities. So you cannot fully control as an individual what impact your decision to share data with a particular player will have on yourself in the longer term and also on others that relate to you. And I think this trade-off is becoming particularly important, although we don't really see it very explicitly in choices made in these legislations. And I think it's important to devote attention to it, because this also will show us how these different areas of law and areas of regulation relate to each other, interact with each other, both in terms of substance, but also in terms of enforcement. So I think the key obligation in the DMA where you see this trade-off is the one that is about requiring gatekeepers to refrain from combining personal data across their services unless they have the consent of the individual to do this. So this stems from the German Facebook case where Facebook was held liable under abuse of dominance for not giving individual users a choice to decide to have their Facebook data combined with data from other services related to Facebook, like Instagram, WhatsApp, but also third-party services. So individuals basically had to consent to that combination of data, otherwise they would not be able to use the Facebook social network service. And so the outcome of this case, and also I think the framing of this obligation in the DMA makes sense, because on the one hand, you can say, well, indeed, it's up to an individual to decide how personalized a service should be. So if you are not so privacy sensitive, maybe you're perfectly fine with your data being combined across across services, because this gives you a better, more personalized service. But on the other hand, if you look at it more from the collective interest and from the perspective of competition, contestability as one of the objectives of the DMA, you can wonder whether it's a good idea to leave this choice as to personal data combination in the hands of the individual, because this would also mean that in the end, the effect on markets overall and on competition and contestability overall depends on the aggregates of all the individuals that users make. So if many individuals still consent to this, to their personal data being combined across services, there is apparently no problem from the DMA perspective, because then you have the end user's consent, but you would still not have competitive or contestable markets. So in this regard, I think you can really see there this trade-off between the collective and the individual interests. And in fact, we already know a lot also in data protection on how consent of users can be nudged. There is biases of users, there is the privacy paradox. Indeed, you are not always able to predict in advance what will happen when you decide to have your personal data combined and what the impact on others can be. So I think it's very tricky to leave this decision to individual users, and I don't think it fits with the overall objective of the DMA to let that important decision up to the individual. So in this sense, I think the DMA could have gone a step further, and this is where I move towards the Data Act, because in the Data Act, you also actually see this trade-off. So for those of you who are not familiar with the Data Act, so the Data Act is basically about giving additional rights to users, so both individuals and business users, to get access to their data. It's mainly focused on IoT devices. So under the Data Act, you would get additional rights to have access to your data and to also provide that data to a third party that could offer you a complementary service. So for instance, a repair services, if you think of connected devices or automated vehicles. And what is interesting in the Data Act is that there's a provision that says that gatekeepers are not eligible as third parties. So this means that an individual or a business user cannot use data that they obtained under the Data Act and give that to a gatekeeper. And here you see that this limits basically the scope of these newly created rights for individuals, because you can't use the Data Act and those new rights to basically transfer that data and use a service offered by a gatekeeper. And so this is, I think, the very clear example where you see this trade-off being made in favor of the collective interest. But then if you look at the recitals, so I wrote it down here, there's interesting to see that it's more phrased like an issue of proportionality. So it does not refer at all to this trade-off between collective and individual. It says something about given the unrivaled ability of gatekeepers to acquire data, having them as beneficiaries is not necessary to achieve the objectives of the Data Act, and it would in fact be disproportionate in relation to the data holders that would have to give that data to a gatekeeper. So it's not at all phrased around this trade-off, but I think this trade-off is very much behind many of these policy choices that are nowadays made. Then one other additional point that I want to bring up here is that there is also a question on how effective this disqualification of gatekeepers in the DMA in the Data Act would actually be in practice. Because under data protection law, the GDPR, the General Data Protection Regulation, there is a similar type of right to access to data, which is called the right to data portability. So it's a right that you have as an individual to get access to your data from a data controller and transfer that data to a third party. And the GDPR applies across the board. So basically to any data controller, irrespective of their market position, irrespective of how much data they hold. So this raises the question, what will then happen after the Data Act enters into force? Will gatekeepers then just rely on the GDPRs to still get that data? And can they then bypass basically this disqualification that the Data Act has imposed on them? And here I think what is interesting is that you see that also the nature of the legislative instrument will determine what happens in practice, because the right to data portability is part of the GDPR, which is a fundamental rights-based instrument. And in fact, at the time of the adoption, there was a lot of discussion whether data portability was actually a fundamental right. People said it was more like a consumer protection or a competition law animal, but now it is part of the GDPR, and now suddenly also the question becomes, does that then mean that you cannot limit this anymore, even though maybe if many people still use this right to data portability because they are nudged by a gatekeeper to do so, this will have a collective harm that the Data Act is trying to prevent. So here I think you see very nicely how different legislative and policy choices will really determine what happens in practice with how these instruments are being implemented. And this, I think, also brings up the question of enforcement. So you see that these new rights of access to data are really scattered across different legislative frameworks, which each have their own definitions, their own enforcement mechanisms. So the DMA indeed will be enforced by the European Commission with probably involvement of the national competition authorities. If you look at the Data Act, it says enforcement is up to the member state. So the member state should assign a competent authority to enforce a Data Act. It can be one authority, but it can also be more than one. And what is interesting there, that it could be that member states make different choices. So France could decide to give the CNIL the competence to enforce the Data Act, but maybe Germany decides to give the Bundeskartellamt the right to enforce the Data Act. And of course, these authorities have different expertises, different backgrounds. So they might also make different choices on how to interpret these rights. So I think that also shows us that there should also be a lot of attention apart from the substance of the text of these legislations, also a lot of attention to enforcement and especially attention to how to coordinate between different regulatory authorities. And to conclude on this, I think especially this trade-off between the collective and the individual interest will also play a big role in this, because this is something I think that if I speak to a data protection audience, people will immediately say, yeah, well, it's a right, the right to data portability, it's a fundamental right. We cannot limit it at all. But if you speak at a more law and econ audience, they will immediately accept that there is indeed, there could be a collective harm for competition and for innovation that might trump in some cases the right of the individual to have control over their personal data. And I think the DMA will also definitely play a role in that.
Thank you very much. And pointing out that this moving text as
Thank you. Can you hear me? Yeah, you can. Now you can hear me. Wow, yes. That's good. Okay, so thank you very much for inviting me here. Actually, not only is this a nice conference, it's my first in-person conference since I don't know how long. So I very much enjoy being here and seeing so many people. Actually, also very strange that this whole DMA has been discussed and will most probably be decided on now in this phase of pandemic with people not being able to meet. It's really extraordinary that it has been possible to come to a piece of legislation that that is now on the table, because I don't think the people well, since I think it started all at the beginning of the pandemic, and now we're nearly at the end of this thing, which is really extraordinary. Now, so this whole legislation piece has proceeded with remarkable speed. From the Bundeskartellamt's perspective, of course, the DMA is a very important piece of legislation. This is also because the German legislator, we've heard that from Frédéric Jenny just now, has been a bit pioneering in addressing big techs in the German competition law. We've got this amendment, which is already in force since January last year, with this new section 19A that Frédéric Jenny alluded to. And the purpose of this new piece of legislation in Germany, of course, is also to strengthen abuse control vis-a-vis large digital companies. So what are the similarities and the differences between the DMA and this German legislation? Maybe I will have a bit of a different view on some aspects of this compared to Frédéric Jenny, so I'll just offer my view. Now, the DMA requires the Commission to designate these gatekeepers. As we have seen, gatekeepers are companies providing core platform services. And the DMA contains an exhaustive list of what constitutes such a CPS, a core platform service. CPS must be an important gateway for business users to reach end users. That's basically the concept. Now, Section 19A in the German competition law is to a certain degree similar in its general approach. The Bundeskartellamt can designate companies with paramount significance for competition across markets. Maybe just one comment on Frédéric Génie here. He said the CMA has a system with a market investigation, all the other models don't. I think ours is something a little bit in between, even though it's maybe not a market investigation. What we have to do for this designation process, we at least have to do a substantive investigation into this company, which I think is more than just applying quantitative criteria. Well, and looking at this designation process, there are significant differences. The DMA requires identification of individual gateway CPS, whereas the Section 19A designation covers the company as a whole. I think this is a very competition law type of concept. You would always be looking at people having control and being responsible, and that's the company and not the service as such. And then 19A is not restricted to an exhaustive list of services as the DMA, which is already the first point on the list of the fact that 19A is inherently more future-proof because we can start addressing services and companies as they develop, and we are not stuck with a clear-cut definition. Now, the designation process following the DMA might be faster than following 19A because the DMA features these quantitative presumptions, which we do not have at all in 19A. Actually, at the time when this was discussed in Germany, we did many efforts at trying to get quantitative criteria, and we tried from various angles, and we always, in the end, after days of discussion, came to the conclusion that it doesn't really work. And that's why we don't have them. Exactly. Now the DMA features these quantitative presumptions, and the European Parliament has even proposed that these presumptions should not be rebuttable at all, which is of course a very strong point. Now turning to obligations imposed, larger differences become apparent. The DMA contains a static list of do's and don'ts, we've heard, and this is something that's, I think, consensus among all people looking at this project, that these obligations are defined rather specific in a detailed manner. And this is, of course, not very future-proof. This is just a fact that we, I think, have to take into account, especially given the highly dynamic digital markets that we're looking at here. The mechanism in the DMA for updating these obligations, I think, cannot fully remedy this. I'm not so optimistic as Simonetta is on that point, because even though the Commission may add new obligations by delegated act, these delegated acts must not concern the essential elements of the legislative act. I mean, the Commission can only, the scope is narrow in which it can kind of add new obligations. So the leeway for modifications without a legislative process seems to be rather limited. Now, another point, the DMA generally does not allow gatekeepers to justify their behavior. This is, I think, a point Frédéric Génie made. It's a very strict concept. You don't have many options of taking into account as authority or as a company that there might be good reasons in that specific case to have this conduct. Also, the burden of proof is reversed. Gatekeepers actually have to demonstrate their compliance with the DMA at all times. It's a difficult thing, I think. Proposals assert that these that this would result in purely self-enforcing rules. This is something that we have been saying from the outset. We don't really believe in this concept of self-enforcing of these rules. We think that in reality, I mean, we know the companies, we are dealing with them since quite some time, also with the markets and with the products and the services. So our idea is actually that the DMA will still allow companies to argue on an individual basis that with regard to the questions like, is this specific behavior under specific circumstances compliant with the DMA, yes or no? That's the discussions that you will be getting, which leads in our experience to individual decisions in the end. The Commission will have to take decisions with regard to the positions that companies take in the context of their relation with the DMA. So this promise on self-enforcement, we are not so convinced of, actually. Now, turning to Section 19A once more, there are overlaps with DMA obligations. That is also due to the fact that these texts were developed in a similar period of time. Nevertheless, the overall approach of Section 19A differs from the DMA because the obligations in the German context are going to be imposed by the competition authority on a case-by-case basis. So it's not that these obligations will be applicable to all the companies that will be designated. We will be looking at services and then look at whether a self-preferencing issue there should be addressed, yes or no. So companies can demonstrate that their respective practices are justified, but they bear the burden of proof for such a justification. A further very important difference between the DMA and Section 19A is that are the rules on judicial review. Actually, all these pieces of legislation have been very much focused on making procedures faster, because everybody feels that the dynamics of this industry does not allow for 10-year ongoing procedures before the courts. And in Germany, the decision was taken that we would actually reduce judicial review to only one court, which is going to be the Federal High Court in Karlsruhe, and the first level courts will not be taking decisions in these cases anymore. We felt this is necessary. Just consider the Facebook decision from the Bundeskartellamt itself. The decision was from 2019, and it's now been in front of the courts for almost 3 years. Without, that we see when this whole thing is going to be finished. So, so I think these amendments have been rather ambitious. Of course, there is a lot of debate, has been here in Germany, whether that is justified, yes or no. There are many lawyers that think it's not justified. Exactly, and of course, you need to understand that this would not have been possible with a DMA. You cannot change the European treaties with regard to the way judicial review is going to take place. So we had some more options there in Germany to come to solutions that might fit a bit better. So we think that DMA enforcement will include also lengthy court proceedings. Undertakings can dispute that a DMA gatekeeper designation. They can dispute the Commission's interpretation of DMA obligations, and they can argue that the obligations are unproportionate in certain scenarios, and all of this can be discussed at length in front of the courts. So, in a nutshell, there are some important similarities between the two. Both strive inter alia to improve contestability in digital markets. They share some mechanisms, but there are also important differences. In particular, this applies to the way the obligations are imposed. And this, of course, brings a very important question for us. How will Section 19A and the DMA interact in the future? The differences in how obligations are imposed are to some degree linked to a divergent legal starting point. It's clear that 19A is clearly rooted in competition law, whereas, and this is, I think, from our point of view, similar to the UK approach, which strive for company-specific codes of conduct and pro-competition interventions. The thinking behind 19A is more in this line than this is the case with the DMA. And the DMA is it's defined as a regulatory instrument. And so this distinction is reflected in Article 1, paragraph 6 of the DMA, where the relationship between competition law or the DMA and other laws, including competition law, is defined. And it is helpful that competition law is going to remain applicable next to the DMA. So consequently, we will still be able to use Section 19A to impose additional obligations on gatekeepers. Now, to be very clear in this point, I think nobody in the Bundeskartellamt or in the enforcement community in Germany is interested in or has any reason to apply prohibitions that are already a legal prohibition in European law. There is no reason to do that because it already applies. So we will not have any debate on that with the Commission or anybody else, because the rule is there. We don't need to enforce it, hopefully. The Commission will have to do it because she wants to do it on her own. So she will have to take this responsibility, I guess. I know that people have been discussing that NCA's, national competition authorities, will somehow help the Commission in this. Just one remark from, I'm sorry, maybe a bit very experienced competition law enforcer. It usually makes little sense to do investigations for somebody else because the somebody else will usually find that you are not investigating the right things. So this concept that we will be helping the Commission to enforce the DMA when they are the only ones deciding is not good enforcement practice in my view. So I think there will not be so much help from NCAs for the Commission, because the Commission will not be so interested in this help. It's not only that NCAs might have decide to do other things where they have their own decisions to take and their own responsibilities to fulfill, but also that the Commission might not really see this as very helpful. Sorry, I just need to. Now, in any case, cases that we will be looking at, so if we don't enforce the prohibitions that are already in the DMA, what are we going to do with 19A? We are going to look at the things that the DMA does not yet address. That's basically my idea of all of this. We will be looking at the new conduct, the new business models, the new problems that might arise beyond the DMA. But of course, and this is also something where the Bundeskartellamt is very clear in, we want to cooperate with the Commission and with the other enforcers of laws that are in this context. So the question is very much, what is a good mechanism for cooperation? And here I really want to advertise the ECN as a good way for cooperation between authorities. The good thing about the ECN is actually that it never hinders an authority to become active. There is no authority that can say within the ECN, I don't want you to do this, and I'm not going to do it by myself either, but you're not allowed to do this case. That's what does not work in the ECN. So you have a strong incentive for enforcement action. And this is a way of coordination which we think is a very sensible thing to have if you want to have enforcement. So we would very much, we have been promoting the ECN as a coordination instrument in the past. We are happy that the DMA is alluding to the ECN. That was a hard bit of work to come to this. It is not going to be the same as the ECN, but it's at least going to be something like the ECN, and I think this is a good result. My final point is that actually the European Parliament has put up the idea that the Commission should have a veto right in any case that is conducted by a national authority in the area of gatekeepers, let's put it that way. Most probably this is not going to be part of the DMA. There has, of course, been lots of discussion on it. The German government has taken a very clear view on this, that this would be an absolute no-go from their perspective, which, of course, we are totally in line with, because this would really be a game changer in the relationship between the European law, the Commission, and member states, authorities of all kinds, let's put it that way. Okay, so I'll stop here. Thank you.
Thank you very much to all the speakers. So I guess we have time now to take up questions from the floor. Any questions, comments, of course? Otherwise, if people have to warm up. I see Filippo is raising his hand, so I think we have a mic to which we can move to you. Oh, I mean, I can
Okay, I'll warm up with a softball. I think Simonetta alluded well, they were celebrating 80 years from the Microsoft case. I would say we're celebrating 80 years of failed antitrust remedies. So the Microsoft remedy disappeared for a year and no one even noticed it was gone. And we're now seeing the Apple discussion also in the Netherlands, where Apple is just not complying with the remedies. So what should have we learned in the past 80 years of enforcement that should have been incorporated on the DMA, and has this been incorporated or not? Thank you.
I don't know. Okay, I just start with I have a very quick answer to that. I think at that moment, we should have already incorporated technologies. I mean, it was really pretty clear in the remedies, there was interoperability in the Microsoft case, especially. So I mean, one thing we should have done immediately, of course, you can get the advice and expertise from outside, but I think it should have been already inside the DOJ or whatever at that time. So we are a little bit too slow on the more technological approach. Okay, that would be, and then many other things, of course, remedies, being a little bit more proactive in specifying what the remedies should be, something which has not been done with the Google shopping case, for instance. Of course, there were some legal questions perhaps that hindered that, but go for it. I mean, challenge, try it. I mean, it's otherwise nothing is going to change. So now perhaps on the other side, the DMA goes for it. It's a little bit a reaction to what you were quite correctly saying. So 80 years of not very effective enforcement in terms of remedies as well. So that would be my take.
Reactions from your side?
Yeah, sure. I could follow up. Indeed, I think you point at the exact weak spot that we really have, and I don't think the DMA will solve it as such. I think on the remedies part in the competition context, I think it's indeed important to be much more prescriptive in many cases, and we've seen that also in the Google shopping case. The Commission basically just refers to equal treatment and then leaves it up to the dominant firm to come up with a proposal, and then you have a whole procedure where complainants come to the Commission has to investigate again if the complainants are right or not. So there is a whole process that then has to be started up before you actually reach the outcome that the remedy is not working. So maybe one idea would also be to focus much more on the outcome. So make the dominant firm responsible for achieving an outcome that is laid down in the decision by the European Commission. And then if the outcome is not achieved, then there could be a process automatically by making sure that this outcome is achieved as soon as possible. I think often in competition law, the remedies indeed still follow from how the abuse is established. And that often means that there is a procedure put in place that needs to be followed. Whereas if you really want to capture the competition problem and solve it, I think maybe one idea would be to be much more focused on the outcome rather than on the procedure that follows from how you have determined the abuse.
It's easy to discuss these old cases as you have done so, and I agree in substance. I don't think that anybody 18 years ago would have known better what to do about Microsoft. I'm not sure, but I think many people have learned very, very much in the last years. And we are confronted with a development that is much faster than anything we have seen in other changes, developments in economy. So I'm not saying be a bit more patient, because of course that doesn't work. The DMA is the effort to become much faster and much clearer. And at the same time, we are discussing here now, are those obligations the right ones? And this problem, I think, to come back to Inge's point, look more at the outcome. You could try to look at the outcome. I would, as a competition enforcer, not look so much to the outcome. I would like to look at remedies that change incentives, because that's, I think, or change the way certain transactions evolve in, and because otherwise you would, if you only look at the outcome, you will be looking at very, very many outcomes. You know, every transaction has an outcome. So it's difficult to keep pace with that. So competition lawyers or competition enforcers look very much at structures that lead to different outcomes. I think this would be our way of looking. And we are always trying to look for remedies that really make a difference in the way also the company that has to fulfill these remedies structures its incentives, the way to look at the counterparts. And I think this is what we need to do. And I'm absolutely with everybody saying that we still have to learn a lot about the right way to do that.
One follow-up question: wouldn't that mean to have like much more structural remedies, divestiture, enforced divestiture?
Yes. I'm personally absolutely not in favor of behavioral remedies for mergers. I think this is totally the wrong way to deal with mergers, because mergers are about a change in ownership and control about a business asset. And if you want behavioral remedies, then you are in an abuse scenario. You just have to imagine what happens. And in Germany, we had these cases in long ago, at times when we also still did in behavioral remedies. What happens if after 10 years and your remedy is going for 20 years? We've had these cases at the European level with remedies, behavioral remedies in mergers, which are supposed to go on for 20 years. What are you going to do if the companies don't fulfill the remedies anymore at 10 years? Are you going to undo the merger? That's not really a sensible perspective. And yes, I would be quite convinced that structural remedies lead to different incentives, and this thus would help more. On the other hand, we also know that, I mean, Frédéric Génie has explained this in much detail, that in network industries, you have strong economies of scale and scope, which lead to problems that you can't just kind of cut up these companies. It's not the only solution. It's not sufficient. But yeah, they don't need to become stronger by acquisitions.
I had a question from Wolfgang Kerber over there.
I might have a provocative question for all of us, especially for us economists. What is really the role of economists now in the application of the DMA? Because I see the DMA also as we have replaced our rule of reason mechanism of examining the effects of a behavior on consumer welfare in Article 102, have you replaced now with per se rules. And per se rules, I only have to look whether the firms are complying with it. And the question is, do we need economic analysis for looking whether they are complying with these rules? I presume yes, but how? What exactly are doing we here? And it would also be interesting, and this is a question to you, Silke, also, how is this in paragraph 19a? To what extent do we need economic analysis in the traditional sense when you make a case in 19a? Also for a deciding sense that something should be prohibited according to 19a. Because you have also a kind of rule approach, but it's not a per se rule approach. I have understood this. So the question is, what is the role of us economists? The task of us economists now in the application of these new DMA and 19a?
Please.
For the DMA, it's difficult to say, and I guess it depends a bit on how clear and self-enforcing the rules will be in the end. As I said, I don't think they are so self-enforcing. And then at least there is a role for people outside the Commission to engage in discussions on what is the substance of the rules and are they complying, yes or no? I mean, very much of the conduct that is going to be regulated by the DMA is obvious for users, so you can see whether or not they are still self-preferencing. You can at least see the results, let's put it that way. The mechanisms behind are, of course, more difficult to understand. So there might be a scope. With regard to 19a, there is more scope for discussing what is, when might a prohibition that we would look at because people think that we should apply it or we think we need to look at it, whether there might be a justification for the specific company to apply this conduct, maybe because of competition between the gatekeepers or the ecosystems, as one point that Frédéric Génie pointed out, or other developments which might lead to this. I think this is still very difficult to say currently. What I think is a broad possibility of situations that might arise.
Yeah, so I think indeed also that compared to competition law, the DMA is indeed much more legally oriented with the per se rules, but I also agree that many of these obligations still have some doubts on how exactly they will be implemented and how exactly they can be applied across the different business models, because some of the obligations clearly come from existing or past competition cases, but they might not be one-to-one applicable to another company, for instance. And then maybe one other point that came to my mind just listening to you as well is that maybe the role of economists in competition enforcement could then become bigger because the DMA does not cover everything, and we still need competition law, I think, to develop and also to spot the potentially problematic behavior that is not in the DMA. And as business models will evolve, as practices will come up that are not in this list of the DMA, which is very backward looking in my view, I think maybe the role of economists would actually become bigger in competition law as such, which may lead to the fact that a whole framework will become more effective so that the DMA would be much more legally oriented, and then a lot of scope is still available for competition law and for economists to help with enforcing the DMA and by complementing the things that the DMA does not target. So maybe a shift in focus.
So very brief, perhaps I would make a distinction between the different roles that economists have. So from the point of view of consultancy, okay, in private practice, well, definitely, perhaps with regard to the DMA, apart from quantitative criteria and things like that, they will have less to say. But then, of course, they will be quite, I mean, let's see, but I think the economists will be needed still, even from the consultancy part. As I tried to allude to before, I think there is quite a lot of interesting work to do for a little bit more academic or theoretically oriented economists, because I, of course, not think a little bit out of the box of industrial organization, that's for sure, okay? Perhaps a little bit more of innovation, economics, but also to understand, I mean, what's contestability, what fairness? Of course, you have to do also work like lawyers do, okay? Where do they come from, these criteria? But I think there is really a very important role there for trying out different things, okay? Perhaps going back to things we know, or do liberalism, or perhaps different influences for other branches of economics. So in that respect, I think there is interesting work to do.
Thank you. Over there,
my question also concerns the remedies. I have problems understanding that in those cases where a case team investigates the case, the company, the problem at hand, and they can't come up with remedies which are, work out in the end, that we know with the DMA have strict rules for everyone, remedies for everyone, without understanding the business model behind it. So I'm lacking in imagination how that should work here. But as a question, I think it's so much uncertainty, understanding the business models, and that it's so much dynamic. We need one approach could be to have more explorative remedies, so that you can, control the remedies, and after half a year you decide, okay, was the right one, we should have a new one, and so on. And now, as a question, my understanding is that with the 19A in Germany, you have the opportunity to say after 6 months, that was the wrong one, we go for a new one, because you have much more leeway to intervene in the market. So is this right? Would that be a correct interpretation of the 19A, that you can also experiment with the remedies and change the remedies after the shorter period of time, which apparently the DMA won't give you, because there you need a longer procedure to change the rules in DMA.
Half a year, of course, is very little for, I mean, I understand very well that people are impatient and want to see the right remedies and not the wrong ones and half good ones, etc. That's all very, very, very well understood. On the other hand, irrespective of Section 19A or the DMA, we are conducting legal procedures. And these kind of procedures do, we have to fulfill certain standards, proportionality issues, rights of defense, and of course also a bit what's important to be able to enforce such laws is that you need to create a measure of legal certainty. A measure of, I mean, it's not, only black and white, but so I guess we will have to see whether it's difficult as an authority to say, look, my talk from 6 months ago is rubbish. We have to do it all over again. We will, it's not so easy. Huh? You would need to demonstrate why these remedies are really not at all suitable, and you really need to do something completely new. But yes, it would be possible, I think, yes.
No.
I mean, I would have maybe a final question concerning the whole legislative process. So, I mean, given the general regulatory approach, right? So you would think maybe one of the most important things is that you ex ante think about very deeply about every kind of single, behavioral rule you have. You're balancing, all the interests, and then the legislator come up with the result, right? And But for instance, now you have mentioned interoperability, which is now very contentious in regard to messaging services and social networks. And when I was following the political discussion, so I had the impression that, okay, there were like technical arguments in a strict sense, and then there were legal arguments, but I haven't really heard about economic arguments or about arguments, you know, how would that exactly shape the competitive landscape in the future? So that's why I'm quite skeptical. And what's your opinion about that? So does the legislator has, you know, really considered carefully enough, you know, all the lists, and what in particular about interoperability, for instance?
Well, they have considered the fact that we had, for instance, in the EU Microsoft case, a big interoperability issue there related to interfaces. And then there has been, for instance, Neelie Kroes, who was commissioner, competition commissioner at that time, and then became digital, in charge for digital, I can't remember exactly the name, digital policy commissioner at that time. And he said, well, actually, interoperability is a big issue, and that at that time, it was 2010, she said, well, wouldn't it be nice to solve all those interoperability degradation issues by those big players in one go, okay? So they have been thinking quite a lot about it, okay? So it's not what we see now, perhaps not so much from the side of DG Com, but the DG Connect and the others there, they have been thinking quite a lot about these issues. Then, of course, now you come with something which immediately allows for in-app purchases, choosing your payment provider. Okay, it's a big change. Yeah, let's face it, it's a big change with many unknowns. Okay, but I mean, we discussed today platform to business regulation. This is also a piece of regulation. We have regulation everywhere. Okay, then he said, well, yes, incentives, definitely. Innovation incentive is a big issue here. Well, it's definitely that you have to be very careful about standardizing specific functionalities, which are already pretty well known. So you shouldn't be hampering a new innovation in that respect. That for sure, but also let's think about the meaning of innovation, basically. Okay, innovation is just that we let Facebook introduce a new functionality, or do we want to create by way of protocols, for instance, ways of having interoperability, which really makes sense also in this, not only perhaps for narrow framed competition issues, but in the sense of really generative interoperability, thinking about the type of society, et cetera, we want to be. Definitely, we are going beyond the normal topics that competition economists and competition enforcers discuss, that's for sure. But I don't think they are just going for that. I mean, they have been this interoperability, they have been discussing thoroughly, for sure, for at least 12 years.
And I think one thing to add on interoperability, of course, there is a legal and economic argument sort of tied to the whole competition policy discussion. But I think there's also a very strong public interest in interoperability in some circumstances. I still remember very well what happened with the Brussels attacks. I was living in Leuven during my PhD at the time. And what happened then was that the regular phone network fell down and people could not contact each other. So if we would have an interoperability between instant messaging services, this can also serve the public interest in times of emergency. And I think this also points to another role that these gatekeepers have. They have very strong power in markets over competition, over innovation, but they are also becoming public infrastructures. We are relying on them for public tasks that are really key to our lives. So I think in that sense, interoperability is also a very interesting example where I don't see the regular legal and economic arguments, but also the more sort of public service argument that could come into play. But I don't think this has been sort of taken into account in the debate so far, but I think it would add another argument in favor of having some form of interoperability. And maybe this also brings in another element that would have to then be done indeed by the legislator in this balancing. So not only considering competition, innovation, but also a public interest, considering this strong public infrastructure task that some of these platforms are also taking up.
thinking of catastrophes. I live in the Valley of the Aar, where we had the flood last year. And unfortunately, their interoperability wouldn't have helped because there was no electricity anymore. So there was no option to contact each other via telephone, email, SMS, or messaging services. So it's, yes, of course, there are situations where this might help and others where even that doesn't help. I'm not so sure whether, I think the debate on interoperability, at least on the surface, seems to concentrate very much on messaging services. And I'm not really convinced that we need interoperability there, for point one. And secondly, I don't know, at least this is of course a very competition law perspective maybe, whether there are companies that are very much interested in interoperability here. It's not that there is a strong, movement among the competitors of WhatsApp that they all want to be compatible with WhatsApp. On the contrary, they distinguish themselves from WhatsApp because maybe they protect data better, for example, than if you would be using WhatsApp, and they don't want to go into the system. And many people have been changing their messaging services from WhatsApp to Signal or whatever because they do not want this data sharing. So, I mean, there are mechanisms also currently in this messaging area which are not don't make it obvious that interoperability is really the most necessary thing currently. So,
okay, thank you very much. Maybe this has already been decided by now, but we do not know. Thank you very much for this excellent roundtable we had tonight, and thank you very much for being so patient with us.